after a short hiatus, I'm back with another review of recent developments in family law and in legal blogs. The more eagle-eyed amongst you may have noticed that I've got around the slight problem with the title to this video by adding an S to the end of the word week in the titles you've just seen. Pretty clever, eh? Oh, and for Paul, who commented on the blog during the week, no, I haven't had my hair cut. I like it like this. And besides, if I were to have it cut, I'd lose what little strength I've got left. Okay. Well, the theme for this video seems to be suing lawyers. I'll start with the case of Williams and Thompson Leatherdale, in which Carol Williams sued her lawyers for negligence for failing to advise her about the impending case of White and White, the decision in which could have led to her receiving a larger settlement. Unfortunately for her, Mr. Justice Field found her to be a profoundly unreliable witness whose evidence was self-serving, evasive and on occasion knowingly untruthful. She therefore failed in her claim. I'll quote a little bit more detail from the judgment. As I say, by Mr. Justice Field. He concluded as follows: as against Mr. Francis, that was Mrs. Williams' counsel, Mrs. Williams has failed to prove that if she had been advised as she said she ought to have been by Mr. Francis, she would have postponed any settlement negotiations until after the White decision. As against Thompson Leatherdale, her solicitors, Mrs. Williams has failed to show that the firm was negligent, and also failed to show that she would have repudiated the settlement agreement if Thompson Leatherdale had acted as she alleges they should have acted. So quite a warning to prospective or disgruntled, I should say, clients. The next case is that of White and Withers LLP, involving Mr. White, who I understand is a celebrity chef, not that I know much about that sort of thing. He felt that his wife's solicitors had been, shall we say, complicit in taking and retaining certain of his documents. He alleged that his wife took the documents on the instructions or at the encouragement of her solicitors, who were of course Withers LLP. Unfortunately for him, he had no evidence to support the allegation, which was denied both by his wife or ex-wife and by Withers as well. His claim was therefore struck out by Mr. Justice Eadie. So, what are the rules relating to taking documents belonging to your spouse? Well, in a nutshell, they're as follows. Firstly, it's clearly impermissible to take a document if that involves intercepting post or breaking into a desk, for example, or a vehicle. Secondly, documents left lying around, well, they can be copied, but the third point is that if the other spouse should demand the return of the documents, then they should be returned, although it seems that it is permissible to retain copies. Perhaps the biggest story of the week, except maybe for the Baby P case, which I'm not going to deal with, is the proposals, or are the proposals, for reform of family law that it appears the Conservative Party are likely to take up. Generally it seems that they haven't been met very favourably, certainly if the comments on this blog are anything to go by. The proposals seem to include the following: firstly, making it more difficult to divorce, although not quite sure how. Secondly, making prenuptial agreements binding, something that is likely, I think, to happen in the not too distant future in any event. Thirdly, the laudable proposal that children should be prevented from losing contact with their fathers and grandfathers. Again, not quite sure how that's supposed to happen. Making divorce settlements more consistent. I don't know about that one. As I suggested in the post about it, I don't see entirely how that can happen if we're going to retain a discretionary system. Then they suggest setting up a network of family relationship centres which can help separating or divorcing couples. Not quite sure how that differs from relate, but there we go. Also not at all certain where the money's going to come from for such a thing. Finally, they indicate that they would scrap plans to give property rights to cohabitees, which they see as undermining marriage. As I say, I don't think the legal profession has generally reacted very favourably to these proposals. Well, moving on to lighter things, we have the story of Dave Barmy, who got into a spot of difficulty when his real wife found that he was having an affair, or if that is the right way to put it, with another woman in the online world of Second Life. I suppose this is a sign of the times, or perhaps even a sign of things to come. But what amused me most of all about the story was the rather obvious difference between the real Dave Barmy and his virtual alter ego. In my blog post I link to the Times story on this, and at the top of the Times story they have two pictures, one of the real Dave Barmy, or whatever his name is, and one of the virtual Dave Barmy. If you flick between the two, you'll see what I'm getting at. And finally, I want to mention a post by Caron QC, in which Matt Mutley of Mutley Dastardly LLP picks up upon an extraordinary quote from DLA Piper Joint Chief Executive Frank Birch. DLA Piper are, like so many firms, reducing their exposure to bank credit by suggesting that income partners contribute capital and get a slice of the pie. And he's quoted as saying, "Everybody who is a partner in the firm will have some skin in the game, and as you evolve and progress you will contribute more capital and have more skin in the game." Well, I recommend you have a read of the post to see what Matt Mutley has to say about that. Right, that's all for this edition of the week, or Weeks in View. Hope you found it of interest.